"She hasn't been part of this family in years," my father said to the mediator, his voice measured, practiced. My sister-in-law nodded beside him. Honestly, removing her name was just tidying up loose ends. She made her choice. I didn't respond. I didn't look at them. I kept my hands flat on the table and my breathing even. Then the mediator set down her pen, looked across at my brother's lawyer, and asked one question. "Counsel, are you certain your clients understand who they're sitting across from?" The lawyer's hand stopped mid-note. The room went very quiet, and for the first time since we'd walked in, my brother looked uncertain. I had learned early that silence does more work than most people give it credit for, especially in rooms where someone expects you to react. The mediation center was on the 14th floor of an office building in downtown Toronto. It was a practical space round table, neutral walls, a window overlooking a stretch of King Street where the afternoon foot traffic moved without any awareness of what was happening above it. No courtroom drama. No gavel. Just fluorescent light, recycled air, and a clock on the wall that moved forward regardless. My father sat to my left. He wore a dark gray blazer, the one he reserved for occasions where he wanted to appear both grieving and reasonable. He had perfected that combination over many years. My sister-in-law, my brother's wife, sat beside him with a manila folder resting beneath her hands. Her expression was composed. She had that particular look of someone performing cooperation while quietly controlling everything in the room. My brother sat slightly apart, which was new. Across the table, my attorney had a legal pad open but was not writing. We had already discussed how the opening would go. I sat straight, shoulders level, feet flat on the floor. Not tense. Not performing calm either. Just settled, the way you learn to be in environments that are designed to unsettle you. The mediator, a senior family law practitioner appointed by the estate, introduced the matter formally, a dispute over shareholder amendments to the family business trust. A challenge to the removal of a named beneficiary, me, from the company structure following my father's medical diagnosis 18 months earlier. A question of who had standing, who had authority, and what my father had actually understood and consented to when the documents were signed. My brother's lawyer stood first. He was thorough, composed, the kind of counsel who believed facts alone were enough. He explained the amendments, the timeline, the administrative rationale. He said that I had been absent from family life for several years, that I had not been involved in the business, that my removal reflected, he paused carefully, a practical recognition of reality. She made her own choices, my brother added, without being prompted. She moved away. She stopped coming home. We respected that. Then my father leaned forward and said the line, the one that had been prepared for him, or perhaps that he had rehearsed on his own. I couldn't tell anymore. "She's not part of the business. She never really was." Keeping her name on the documents was just leftover paperwork from a different time. Leftover paperwork? My sister-in-law tilted her head gently. "We just updated things to reflect what was actually true," she said. Her voice was soft, reasonable, almost kind. I felt the air in the room change, not dramatically. A shift, the way a room feels just before weather moves in. I didn't react. I didn't need to. The mediator made a note. Then she set her pen down, looked at my brother's lawyer directly, and asked, "Counsel, are you certain your clients understand who they're sitting across from?" It wasn't loud. It wasn't hostile. It was precise. The lawyer paused barely, but enough. "I'm sorry?" The mediator held his gaze. "I want to make sure we have a full and accurate picture of the parties involved before we proceed. Are you representing that your clients are fully informed about the petitioner's professional background and current standing?" The lawyer glanced at his notepad. My sister-in-law's jaw tightened slightly. My brother looked at my father. My father looked at me for the first time since we'd sat down. I looked straight ahead. The mediator folded her hands. "We'll take a short recess. 15 minutes. I'd like counsel to confirm they're prepared to proceed with full disclosure." She rose. The room followed. I had not planned to end up in that room. Not this way. Not at this point in my life. There were other things I was supposed to be doing, things that demanded attention, preparation, and a very different kind of focus. But records don't wait for convenient timing. The hallway outside the mediation suite was quiet. Pale carpet, neutral art on the walls, the muffled sound of another meeting happening behind a closed door somewhere. My attorney stopped beside me and said nothing for a moment, which I appreciated. "They came in overconfident," he said finally. Yes, I said. I noticed. He studied me briefly, then added, That's useful. It was. Overconfidence makes people sloppy. Sloppy people make statements they can't support. Unsupportable statements create records of their own. I crossed my arms loosely and let my breathing stay even. Down the hall, my brother was speaking rapidly to their lawyer. My sister-in-law stood slightly apart, her folder open now, flipping pages with purpose. My father sat on a bench near the window, staring at his hands. He looked smaller than I remembered. I hadn't let myself think too much about that. Grief and accountability can coexist, but you have to keep them in separate rooms or neither one gets resolved properly. The truth was, my absence from the family had not been an accident or a rebellion. It had been a decision made under circumstances that the people in that hallway had either forgotten or had preferred to reframe. When my father's diagnosis came early-onset vascular dementia, caught during a routine check after a minor fall, I had been the first one to call the neurologist. I had been the one to research care facilities, to understand what the progression would look like, to coordinate with his GP. I had been doing that from a distance while managing everything else, because that was how I operated. But I had not been in Toronto. I had not been at the Sunday dinners or the board meetings, or the quarterly reviews that my brother ran while my father's signature was still being collected on documents. That, apparently, was what had made me convenient to erase. My mother had passed 6 years earlier. Cancer, swift, and then slow, and then over. After that, the house shifted not loudly, not with confrontation. My brother had married 2 years prior, and his wife had stepped quietly into a role that no one had formally assigned. She was organized, capable, and very good at paperwork. She became indispensable in the way that certain people make themselves indispensable by becoming the person everyone goes to before they think to go to anyone else. I had been building something else. Something that required my full attention and had taken me away from Mississauga, then from Ontario, entirely for a stretch, before I came back to the city but not to the house. My father and I had still spoken, for a while. Phone calls that grew shorter, and then less frequent, and then stopped. I had told myself it was timing. Later I understood it was management. Someone had been managing the distance. When I found out about the amendments, it was not through a call or a letter. It was through my father's accountant, a man I'd known since I was 12, who had quietly forwarded me a summary of the trust restructuring with no comment other than, "Thought you should see this." I read it twice, then I set it down, then I made a list. I did not call my brother. I did not call my sister-in-law. I called a lawyer. The first meeting with my attorney lasted almost 2 hours. He asked me at the end, "What outcome are you working toward?" I thought about it for a moment, because I took the question seriously. "I want the record corrected," I said. "Specifically, I want documentation that my father was not in a position to provide meaningful consent to those amendments when they were signed." He was quiet for a beat. "Not compensation?" "Accuracy first," I said. "Then we'll see what the record says." He nodded once, and the tone of the entire file changed. In the weeks before the mediation, I kept my routine. Early mornings, movement, focused work. I reviewed the corporate documents the same way I reviewed any complex structure systematically, with attention to what was stated and what was conspicuously absent. The pattern was clear once you knew what to look for. The amendments had been initiated 18 months ago, within weeks of my father's formal diagnosis. The signatures had been collected across multiple documents, none of which appeared to have been reviewed by independent legal counsel on my father's behalf. My sister-in-law appeared on nearly every page as either witness, facilitator, or signatory for a related numbered company. My father's signature appeared on 6 pages. On 3 of them, the handwriting was notably different from his baseline. I did not speculate about intent. I let the timeline speak. There was one more thing. I had asked my father's accountant, the one who had quietly forwarded the summary, whether he knew of any prior documentation of my father's intentions regarding the family trust. He had paused. Then he said, "There might be something." What he found was not dramatic. It was a letter, typed, printed on plain paper, signed by my father, and dated 4 years earlier, well before the diagnosis. It had been stored in the physical files at the accounting office because my father had been deliberate about keeping redundant records. He'd grown up watching his own father lose a business dispute over a single missing document, and it had stayed with him. The letter outlined his intentions for the company structure. It named me specifically, not sentimentally, practically as a named beneficiary with equal standing. It stated clearly that any amendments affecting that standing were to be made with the written involvement of all named parties. That letter had not been referenced in any of the subsequent filings. When the recess ended and we returned to the table, the atmosphere had shifted. My brother's lawyer was quieter. My brother sat with his arms folded. My sister-in-law's folder was closed. My attorney rose. "Before we continue," he said, "we'd like to establish the petitioner's standing and background formally on the record." The mediator nodded. "Go ahead." "Miss Caldwell," my attorney said evenly, "can you state your current professional role for the record?" I answered clearly and without pause. "I am a licensed physician. I practice emergency medicine at a Level I trauma center here in Toronto. I hold a faculty appointment at a university-affiliated teaching hospital. I have for the past 7 years. The room shifted the way rooms do when a variable changes and everyone in them recalculates at once." My brother's lawyer looked up from his pad. My sister-in-law looked at my brother. My father looked at me with an expression I hadn't seen from him in years, something between surprise and something older, quieter, harder to name. My attorney continued without dwelling on it. He didn't read out commendations or list publications. He simply established that my absence from family dinners had not been a retreat into irrelevance. It had been the byproduct of a demanding career built on precision, accountability, and the understanding that records matter in hospitals, in courtrooms, and in corporate trust structures alike. "Dr. Caldwell," my attorney continued, "are you familiar with the documentation standards required for valid amendment of a family business trust under Ontario law?" "Yes," I said. "And have you reviewed the amendments in question?" "I have." "What did you observe?" I spoke carefully. I described timelines. I described the sequence of signatures relative to the documented progression of my father's condition. I described the absence of independent legal review. I described the letter from 4 years earlier, and where it had been stored, and why it had not been referenced. I did not editorialize. I did not assign motive. I simply put the facts into the record in the order in which they had occurred. My brother's lawyer objected twice. The mediator overruled him once and asked him to let me finish the second time. When I was done, the mediator asked my father's lawyer, the one appointed to represent his interests independently, which had only been arranged after our initial filing, to respond. He was brief. The independent representation had been a condition of our agreement to mediate at all. My attorney had insisted on it. When my brother finally testified, he spoke about intent, about doing what was best for the business, about protecting the company during a difficult transition. He was not unkind in his language. He was careful. But he made one mistake. He said, "She wasn't involved. We had to make decisions without her. That's just what happened." The mediator looked up. "Were attempts made to include her in those decisions?" My brother paused. "Counsel?" the mediator said. His lawyer said something low and carefully worded. The mediator wrote something on her pad. My sister-in-law testified next. She was polished, prepared, precise. She explained the administrative rationale. She used the word practical 4 times and the word oversight twice. She said the letter from 4 years ago had simply never come to her attention. The mediator asked, "Was it your responsibility to ensure all existing documentation was reviewed before amendments were filed?" A silence stretched for exactly long enough. "I relied on the information that was provided to me," my sister-in-law said. "By whom?" She named the external lawyer who had handled the filing. He was not present. My father was asked only 2 questions by the mediator. She spoke to him directly, gently, with the careful attention of someone who understood his condition and was not interested in theater. "Mr. Caldwell," she said, "at the time these documents were signed, were you aware that your daughter's name was being removed from the trust structure?" He looked at his hands, then at the table, then at some point in the middle distance. "I don't recall it being explained that way," he said. "Were you given the opportunity to read the documents before signing?" "I trusted that it was being handled," he said. The mediator nodded, wrote something, and closed that line of questioning. There was a short recess. In the hallway, my attorney said nothing for a long moment, then, "They're exposed and they know it." "Yes," I said. "Your sister-in-law is going to try to settle before a formal determination." "I know," I said. "Let her try." He raised an eyebrow. "I'm not interested in a settlement," I said. "I'm interested in the record." He smiled faintly. It was the same faint smile he'd given me in our first meeting when I'd said accuracy first. When we returned to the table, my sister-in-law's lawyer asked for a brief adjournment to explore resolution. The mediator granted 30 minutes. My brother found me in the hallway. It was the first time we had been physically alone since the mediation began. He stood at a careful distance. He looked tired. The kind of tired that has nothing to do with sleep. "This could have been handled differently," he said. "Yes," I said. "It could have." He looked at the floor briefly, then back up. "I didn't know about the letter." I said nothing. I had learned not to fill silences with reassurance they hadn't earned. "I genuinely didn't know," he said again. I believed him. Partly. I also understood that not knowing was itself a choice, when the alternative was looking too carefully at what was happening under your own roof. "I want Dad's name protected," he said finally. "I don't want this to become a public thing." "Then make sure what you file going forward is accurate," I said. He looked at me for a long moment. I couldn't tell what he was calculating. Eventually he nodded once, stiffly, and walked back toward his lawyer. When the full session resumed, the mediator delivered a preliminary finding. She was methodical, clear, unhurried. She found that the amendment process had not met the standard for informed consent given the documented progression of my father's cognitive health at the time. She found that the prior letter of intent constituted material evidence of my father's established wishes that had not been appropriately considered. She found that the petitioner's standing as a named beneficiary under the original trust had not been lawfully extinguished. She concluded, "The amendments in question are set aside pending corrective restructuring. The petitioner is to be reinstated as a named beneficiary with full standing under the original terms. Independent oversight is required for any future amendments while Mr. Caldwell's capacity remains subject to medical assessment." She closed her folder. She looked at everyone at the table in turn, without drama, without judgment. "Records," she said, "are not a courtesy. They are a responsibility." There was no applause. There was no dramatic reckoning. My sister-in-law gathered her folder. My brother stared at the table. My father sat very still. I walked out. The elevator doors opened onto the lobby, and the city continued outside the glass, in that particularly indifferent way cities have during other people's significant moments. My attorney joined me on the sidewalk. The afternoon was gray and cold in the way that Toronto in late October is gray and cold completely. Matter-of-factly, without apology. "It's over," he said. "The first part is," I said. He gave me a look. "The restructuring will take months," I said. "Independent oversight needs to be set up. My father's capacity assessments need to be coordinated with his care team. There are still 4 numbered companies to account for." He nodded slowly. "Right. Yes." "I know," I said. "That part never makes good stories." He laughed a short, genuine sound. "No, it doesn't." We walked to the corner. He had a cab waiting. Before he got in, he turned back. "Most clients, after a session like that, are either furious or crumbling," he said. "You look like you just finished a shift." "I'm used to rooms where the outcome matters and the atmosphere doesn't," I said. He nodded once more. Then he was gone. I stood on King Street for a moment and let the cold settle around me. I thought about my father, about the version of him that had existed before the diagnosis, before the slow reorganization of the house, before Sunday dinners became shorter and phone calls became administrative. He had been a careful man. He had kept duplicate records because he understood what was lost when paperwork disappeared. He had, without knowing it, left me the one document that mattered most. I thought about my brother. About whether the distance between what he had known and what he had chosen not to examine would eventually close on its own, or whether it required something more deliberate. I didn't know yet. I left that question in its proper lane for now. I thought about my sister-in-law, and I thought about this carefully, without anger because anger is imprecise. She had been effective. She had been organized. She had built something that worked very well, right up until the moment someone looked at it directly. The corrective filings took the better part of 3 months. Signatures, verifications, assessments, restructured beneficiary schedules. The kind of work that happens in offices and inboxes, without witness, without ceremony. My name was restored to the documents where it had been removed. My father's original letter of intent was formally incorporated into the trust record. I accepted what the structure entitled me to. Nothing more. Some people expected a different ending consequences for my sister-in-law, formal proceedings against the external lawyer, a public accounting. I understood the instinct. But institutions move slowly, and I had already accomplished what I had come to accomplish. The record was accurate. My father's intentions were documented. An independent trustee was now in place. Scorch the earth, and you spend years dealing with the ash. My father called me on a Sunday afternoon, 6 weeks after the mediation concluded. I was at the hospital. I called him back that evening. He didn't apologize directly. He was not that kind of man, and the diagnosis had made certain conversations more difficult. But he said, "I looked at the letter. The one from 4 years ago. I remember writing it." "I know," I said. "I meant it," he said. "I know," I said again. A pause. Long, but not uncomfortable. "You look like your mother when you're being patient with someone," he said. I didn't answer right away. "She would have handled this the same way," he said, quietly, "until it was done." "Yes," I said, "she would have." We didn't talk for much longer. His energy faded in the evenings now, and I had learned to read the pauses. Before we hung up, he said, "Come for dinner sometime. Not for anything. Just to come." "I will," I said. And I meant it. I also arranged, through the trust restructuring, for a portion of the advisory fees recovered to be directed toward a local legal aid clinic that handled elder financial abuse cases, the kind of quiet, methodical exploitation that rarely made the news and rarely reached a courtroom because most families either didn't know it had happened or couldn't afford to prove it. I didn't announce it. I just filed the paperwork. There is a version of this story where I arrived at that mediation session ready to fight, ready to tear down everything they had built, ready to make my brother and his wife understand in the loudest possible terms what they had done. I had thought about that version. On the nights when I was tired and the file was spread across my kitchen table and I was remembering the Sunday dinners I hadn't been invited to and the calls that had stopped without explanation, that version felt earned, but earned is not the same as useful. What I had learned in medicine, in the years of residency where sleep deprivation meets impossible decisions, in the quiet of rooms where the next thing you say might genuinely determine what happens next, was that the most powerful intervention is usually the precise one. Not the largest, not the loudest. The one that addresses exactly what needs to be addressed and nothing it doesn't. I had not come to that table to punish my brother. I had come to correct a record that had been altered while my father was not able to protect it himself. That distinction mattered to me. I was not sure it needed to matter to anyone else. Months later, on a morning when the city was still recovering from an overnight snowfall, and the streets had that particular white quiet that belongs only to early winter in Ontario, I stopped at the hospital chapel on my way to rounds. Not for religious reasons. For the same reason, I occasionally walked down to the waterfront in the evening, or stood at the window of my apartment before the building's lights came on. Because stillness is not emptiness. Because sometimes you need a room that has no agenda. I sat for a few minutes. I thought about my father's letter, the careful, practical language of a man who had understood that love and legal documentation were not mutually exclusive. I thought about what it meant to be written into a record, to exist on paper not because someone permitted it, but because the truth required it. I thought about the mediator's last sentence and the clean, exact way she had said it. Records are not a courtesy. They are a responsibility. I stood up and went to do my job. If any part of this story felt familiar, if you have ever watched your own name disappear from a conversation, a document, a version of a family that someone else rewrote for convenience, then you already understand the most important part. You do not need to be the loudest person in the room. You do not need to arrive with fire. You need the facts, you need patience, and you need to understand that the truth, properly documented, does not require your permission to exist. It simply does. If this story stayed with you, take a moment. Think about what records in your own life might need attention, and if you found value in hearing it, consider sharing it with someone who might need to hear it too. We'll be back with another story. Until then, stay steady.